Yes, on the list.
Item number 1 to 5.
Online. Yes, please.
My lord, these are the matters, my lord. Your lordship passed the last order. Your lordship kindly sees, my lord, 20th of February.
Mr. Khurshid Alam is online.
My lord.
Okay. Very nice to see you, Mr. Khurshid Alam.
Great pleasure, Lordship. I'm here to assist you.
Yes.
I'm grateful, my lord. Deeply
I
grateful.
had the pleasure of having you in Calcutta in one matter. You had appeared before me in Calcutta.
But I do.
In Calcutta, you had appeared before me in one matter.
Please, my lords, I was greatly privileged and I'm grateful to your lordship.
It is my privilege and opportunity to be assisted by you and
Deeply
also
obliged,
something
my
in the
lords.
course of
Deeply
it.
obliged.
It's not audible.
My lords, the privilege is entirely mine.
Yes, please.
My lord, your lordship kindly produces the last order, my lord, of 20th of February in these matters, my lord. At page 3, my lord, the last paragraph, if I may just refer to it.
Yes. What is the position now?
So, my lord, my instruction is that originally there were 492 witnesses, my lord.
Yes.
Now 28 have been examined, and pursuant to this order, my lord, the branch office at Shillong, my lord, they've proposed to cut down by 200, my lord. By 200 witnesses. So after cutting down 200, my lord, 292 witnesses will remain as of now, my lord. 28 have been examined, and but the proposal is with the headquarters now, my lord. We are awaiting the final concurrence from the headquarters, my lord. So this is what my latest instruction is. And this is for the time being, my lord. Because here what happened, my lord, they were...
No, since the last order, how many witnesses have been examined?
4, my lord. 4.
After the last order?
Yes, my lord.
So as of now, 28 witnesses have been examined.
Connectivity, good.
Do you have to furnish a list of witnesses to the judge? A list of witnesses, or the list of the witnesses can vary?
My lord, what happened as submitted, my lord, 492 originally listed witnesses, my lord. Now we have proposed to cut it down to 292. So 200 witnesses will be eliminated from the list, my lord.
No, you have to furnish that list to the court.
We will furnish it to the court, but only up to get the concurrence from the headquarters, CBI headquarters, my lord.
Yes, but that list will not vary.
That elimination list, as of now, my lord, we have proposed 200, and we are further
Mr. Alam, I would like to know the law from you. This list of witnesses has to be submitted to the judge. Or could the list vary?
Yes, my lords. Yes, my instructions are that. Well, the original list is already with the honourable judge, but if my learned friend's client will cut down on that list, that will have to be indicated to the honourable judge, my lords.
Yes, but they cannot depart from that list. They have to stick to that list. In the course of trial.
That's correct, my lords. That's correct.
Yes.
That's my understanding.
So you finalize the list, and until that time, the trial should be stayed.
My lord, pursuant to last order, we are acting on this, my lord. We are trying to cut it down almost by half, my lord. 292 will come down, 492 will come down to 292.
Yes, if it comes down to 292, say you have examined 28 witnesses.
My lord.
The 29th witness may not be included in 292.
My lord, also only grants us leave, my lord, to examine to leave out those eliminated witnesses, my lord, and to continue with the remaining witnesses, my lord.
The eliminated witnesses have not been approved by your office in Delhi.
But my lord, we know who are the 200 proposed to be eliminated witnesses, my lord. So
But that is subject to what that is subject to approval in Delhi.
but what I'm trying
But
to
then in
my
the
lord,
meantime, you cannot go on examining witnesses
because even
because you do not know whether they will be included in the final list or not.
no, my lord, 292 witnesses which are after eliminating, my lord, 292 we know, my lord, who are the witnesses, my lord. So we continue with those 292, my lord.
But your Delhi office might cut down on them. Say
No,
out of 292 might say witness number 152 or witness number 72 or witness number 30 may be struck off.
But we have sent specific names, my lord, of the witnesses who are to be eliminated.
That is all right, but that is subject to their approval.
Their approval, my lord. But approval or disapproval will only affect those 200 witnesses, my lord. The other 292 witnesses are still there, my lord. My lord, in my humble prayer, my lord, Lordship will permit us to continue with the witnesses, my lord.
But you are taking so many time to finalize the list of witnesses and saying continue, continue. What you will continue?
My lord, this was only pursuant to the last order, my lord, that was passed on 20th of February.
Yes, sir. You have to make any submissions?
Well, it's fine. We don't have any issue here. The only, as your lordships have observed, we should not be wasting our time on witnesses who will finally not be approved by the headquarters. So they could get a headquarter approval very quickly, my lords, and then we would proceed with whatever witnesses remain. We would proceed, but we don't have very serious concerns here, my lords. One way or the other, as your lordship feels comfortable, we'd be happy. So it's only for the present it's been kept in abeyance, but your lordships have to decide whether it should continue in abeyance till the approvals come, or whether they can continue with some. Your lordships had put it in abeyance. So we don't have very strong views on this, my lords, because we are anxious and we are willing and ready to face trial, and we were proceeding with it. But this issue has arisen because of the indecision that my learned friends' clients have not made clear.
But in any case, my lord, this quashing application which are before your lordship, my lord, that may not have a direct bearing on that, my lord, because the trial is, there was no stay right from the inception, my lord, because these cases were filed in 2023. So if those matters are heard finally, my lord, and if your lordships quash the charges, my lord, then everything is over, my lord.
Yes. Then what would be the purpose of witness examination?
So, my lord, that's what I
If it is not quashed, yes.
Yes, my lord. So, my lord, if the learned senior counsel is, which other matter can be heard, my lord, any day today or any some other day. Because if this is decided, my lord, the other way, my lord, then the examination of witness will become a futile exercise. But then my prayer would be to kindly expedite the hearing, my lord.
We are there to expedite the hearing, but you are sitting over the matter.
Well, in fact, before the other bench, the matter was argued. We even concluded the argument. We even filed the synopsis of arguments, my lord. And then the matter was recused, my lord.
All right. Please take down today. Dr. N. Muzika, learned Deputy Solicitor General of India, submits that the prosecution had prepared a list of 492.
Yes, total 492 witnesses, 200 are to be eliminated.
492 witnesses. Full stop. 28 of them have already been examined till date. Paragraph. By an earlier order, comma, to ensure a speedy, fair, and non-dilatory trial. I had observed that the number of witnesses be reduced. The number of prosecution witnesses be reduced and restricted to those whose testimony would be required to prove the case of the prosecution beyond reasonable doubt, and unnecessary witnesses be left out. Full stop. Today, Learned Counsel submits that the prosecution has decided to omit 200 witnesses and examine the remaining 292, of which 28 have already been examined. Full stop. The proposal of the prosecution is awaiting approval from the CBI headquarters in New Delhi. Paragraph. The first order of this court to effect was made on 9 December 2024. Full stop. On the list, strike out, since the list of witnesses could not be decided upon by the CBI, this matter was further adjourned on 20th February 2025 to this day. Paragraph. Learned Deputy Solicitor General submits that the prosecution be allowed to continue with examination of witnesses for speedy trial. that it is a matter of surprise that from early December 2024, the CBI is sitting over their list, sitting over its list of witnesses to be examined. Without finalizing it, and yet clamoring for speedy trial. Full stop. Paragraph. For a fair and speedy trial, it is essential for the accused to know the exact list of witnesses, the exact names of witnesses who would be examined for the prosecution, to enable it to prepare its defense. Full stop. Paragraph. In those circumstances, today, we proceed to hear the main application under section 482 of the Criminal Procedure Code for quashing of the proceedings. Paragraph. In the meantime, the trial court will suitably adjourn the criminal proceeding to enable CBI to furnish the final list of witnesses to be examined. Full stop. When such list is examined, the trial court may proceed with further examination of witnesses and also proceed with further examination of witnesses and the trial. When would it be next convenient for you, Mr. Alam?
It's the learned court has fixed a date on the low court. Low court, my lords, has fixed a date on the 11th. But if the CBI is not ready by then, and we would need just a little time to reflect. So your lordship should indicate
11th today.
No, my lord. 11th April.
11th of April. 11th of April is the date. So if the honourable other side can proceed before that and ensure that we know which witnesses are to be examined, and we can prepare ourselves for it.
Yes, yes. I have said so in the order. Until that is done, the proceeding will be adjourned.
I'm grateful, my lords. I'm grateful.
Yes.
No, I know that. My lords, as far as
when should we keep these matters again? When should we keep these matters again?
My lords, we are ready. It's entirely on your lordship's
No,
convenience.
today you start the main matter, and then we will fix another date for further hearing.
I'm grateful. I'm grateful. I'll do exactly that, my lords, as your lordship pleases.
Yes. When should we?
Sometime around 15th, 16th, 17th of April.
List all these applications.
Is it?
26 March would be all right.
Well, 26th March is convenient if it's convenient to your lordship. 26th March is fine.
My lord, 26th March, those other matters are fixed, my lord. 26th, 27th, and 28th.
All right. This is a single bench matter, 25th.
Well,
Well, may I request your lordship to take it in first week of April?
Yes.
First week of April.
3rd April, Thursday.
3rd April, my lords.
3rd April. Or 7th April, Monday. 7th April.
7th April, my lord. I'm grateful.
You can start today if you like. The 482 matter. You can give a background. And
Well, I'll start. I'm great. I'll do that. I'll do that. I'm grateful, my lords. I'm very grateful. Your lordships would be kind enough to take up criminal petition number 36.
why? My officer is saying that 7th may be a state holiday here. Then 8th April. 8th April.
I just,
8th April, sir.
lordship will just give me. Well, may I request the 9th, because normally Tuesdays in the Supreme Court are
Yes,
final
yes.
hearing matters. Well, let's say, if your lordship would be kind enough to
9th
take
April.
it on the 9th, which is a Wednesday.
9th April.
I'm grateful. So may I give your lordships the
Yes, yes,
broad
yes.
background of the
Yes.
matter? Well, so this is criminal petition number 36.
Front of the judge. You call whoever is in charge. Yes, please.
I'm grateful. Well, this matter pertains to the selection processes that had been undertaken for appointment of teachers. Well, this matter has a long saga, traveled from the Honorable High Court to the Supreme Court on several occasions, and some matters in the Supreme Court are still pending. And
You prepare a size. This, and it should be thinner. This. Yes, please.
my lords, these matters travel to the Supreme Court several times, and then the judgments of the Honorable High Court Division Bench, etc., intervene to do two things. One is to give these matters to the CBI, and two, to appoint a high-powered committee, so that the high-powered committee could, in due course, examine the CBI reports, etc., and take a view, essentially to distinguish what was called tainted candidates from the untainted candidates. The
Yes.
tainted candidates were sought to be found tainted on grounds of having either been recommended by somebody, which was not permissible under the regulations, or having been given marks that were undeserving in each of the categories in which the marks were given. And for that reason, the tainted persons were removed from service and were disqualified. They came back to the Honorable High Court. Honorable High Court then gave the matter to another high-powered committee. That high-powered committee cleared the taint on some people but found some people still to be tainted. But this is now part of the historical background of how this matter has finally proceeded against the accused in this particular matter. And I'm before your lordships on behalf of accused number 1. There are 3 accused in it. Accused number 1, accused number 2, and accused number 3. Accused number 1 being from the background of holding political office. Accused number 2 being from the background of holding an administrative office. And accused number 3 again being from an administrative office that pertained to the selection procedures. Now, my lords, that's the broad background. As far as accused number 3 is concerned, my lords, because of some conditions which are related to dementia and mental conditions, accused number 3's charges and accused number 3's trial has been severed, my lords, and that is item 37, a criminal petition number 37, but that's independent of this. And I think not much will turn on that, so that we will not trouble your lordships for the present with the criminal petition number 37. So essentially here there is only accused number 1, who I represent, and accused number 2, who is represented by Mr. De Costa, who I'm told, my lords, because of a family grievance and a family Mr. Costa Paul, my lords, who I believe because of a family bereavement is not present before your lordships today. But he's independently appearing for accused number 2. I'm only informing your lordships that he would also have a matter before your lordships which relates to the same prosecution as the one that I'm facing. So, my lords, this is the backdrop of those who are before your lordships. Now, my lords, as far as I am concerned, I have been charged. If your lordships will just very quickly just take a moment to look at the charges that have been framed, your lordship will find them at page 66. My lordship, I'd be grateful if your lordship will just make a note of this. So, my lords, the first charge at page 66, your lordship will see the charge of conspiracy. Is the charge of conspiracy, and I'll have something to say on the charge of conspiracy. If your lordships have that at page 67.
Take out pictures.
This begins at page 66, and at page 67, your lordship will find the first charge, which is under section 120B, charge of conspiracy. Your lordship have page 66 and 67, which is a charge of conspiracy.
Yes.
Yes. Well, it's the next paragraph. The second charge is under section 420 IPC. The second charge is at page 67 again. The second charge is section 420. As your lordships are aware, section 420, offence of cheating. Then there's a third charge, my lords, which is in the next paragraph. which is section 467, forgery, section 467. Your Lordship have section charges, as your Lordship knows, often clubbed with 467. So it's basically forgery for purpose of cheating and using of a forged document. So my lords, that is the next two charges, 468, 471, essentially part of the omnibus of 4. So your lordships have the omnibus of 467. 467. I'm sorry, there is a
Our thing was not working in the morning.
interference, but I'm now going to be able to be on this screen. Well, so 468 and 471 your lordships have.
Yes. But sir, on what ground you are wanting quashing of these proceedings? Are you audible?
Well, I'm sorry, there was some interference. Well, there was some interference.
Our end or their end? Huh? Our end is okay.
It's not I'm joined, but it's.
Yes, Mr. Khurshid.
Yes, my lords, I just wanted to be sure that your lordships had 468, 467, 468, and 471.
Yes.
Thereafter, there is this charge of 201. And my lords,
The
in addition to this,
ingredient,
there's a charge.
the ingredient of the offence being that score sheet, mark sheets, etc. were manipulated by changing the marks. By changing the marks there,
I'm grateful, my lord.
by erasing the
That's it.
existing marks by white fluid and replacing them by new marks so
That's
that
right.
undeserving candidates qualified and the deserving candidates got
Deeply
disqualified.
grateful. Deeply grateful, my lords. That is the gravamen of the charge. All these are just reflections of that charge that you interfered on the say-so.
Yes. Yes, please.
You've got your officers to interfere with the marks. So, my lords, that's where the conspiracy issue comes in. So, my lords, there are two aspects that I would want to bring before your lordships in some considerable detail. One is, are the charges indicative of something that I have done directly? In other words, have I interfered with any of the marks myself? there was some indication in the charge sheet that I may have interfered by getting the mark sheets on my computer. So, my lord, your lordships have very rightly pinpointed that the real charge is that you interfered with marks. Now, interfered with marks and therefore helped undeserving persons get in and possibly eliminated deserving persons. That is the core charge against me. Now, my lords, the issue is your lordships will see the charges as they are framed, the order on charges. Then they have variously said that you did this yourself, that you were present where this was done, that you put the charge, you put the mark lists on your computer, you interfered with the marks on the computer, etc. Those are one array of the issues that have been raised. But in the actual order on charge, none of this appears. None of this appears. So the actual charge narrows down to, was I responsible for telling the officer concerned that please interfere and do the following things, change these marks, etc. That is the central point of the allegation raised against me.
No, but the accusation seems to be a conjoint act by all three.
Well, they've said
And
conspiracy.
in conspiracy with one another.
Quite right. So the issue of conspiracy will have to be settled, and I will show how the conspiracy is not made out.
But Mr. Khurshid, what I am asking you that whether one of them, that is your client, was involved or was an aider, abettor, or in whatever involved with the crime, would be more established or demolished in evidence. But quashing the proceedings at ab initio, there is.
I appreciate. Well, Lords, I must meet the standard of 482. That a lot of this would have to be done at the trial level. Some could have been done at the discharge level, and then beyond the discharge level, it will have to be done at the trial level. I appreciate. So I'm only before your lordships to say that the discharge was inevitable, and on the grounds on which I argued discharge, the order on charge does not indicate that those grounds were taken into account. Therefore, putting me through an entire trial to get acquittal at the end of the trial may be unfair and may be very, very onerous on me. Only to that extent, I have to persuade your lordship that I have a case, that this was a case for discharge. This was not a case. This is not a case for trial. And I do that for this reason. Your lordships asked me, there is something about conjoint conduct, that you've all come together, conspired, etc. So I must satisfy your lordships that that is not the case, and that has not been made out in the order on charge. That's point number one. Point number two is, and I must admit to your lordships, it's only fair that I must admit with candor, that persons in public life came to me and they said, please help us with these candidates. These are candidates from our constituencies. I have written on the slips of paper that they gave, I have written allegedly, please help, bring up, include, etc., etc. Now, if I have done that, your lordships have to consider whether writing on a simple piece of paper automatically leads to culpability, which is of a criminal nature, or there is something else that needs to be examined. And my lords, my argument, as I show to your lordships the details of what has happened, is to show that there is no pattern by which anything that I have said has automatically been observed and done. There is a random pattern in which something has happened, something that should not have happened, etc., etc., which is why I explained to your lordships that a lot of these selections were considered by the Honorable High Court to be tainted selections, without at that point of time saying that any person in high office was involved. At no point did the High Court come to any conclusion. There was no evidence that anybody was involved. Merely said that this does not meet the standards that should have been applied to selection, and therefore these people are tainted. They were removed. Those who were untainted were kept back. Now here, when somebody is being accused of having interfered with marks, it would be important, I urge your lordships to consider whether the act of recommending somebody was sufficient to bring criminal culpability upon you, or whether it was just an act which was to be ignored and not to be taken seriously. Well, it's the order on charge says that all the public persons who made recommendations did it as part of their public duty. They were not expecting that any law should be violated. They were not expecting that anything should happen which is unacceptable in standards of law. They have now, in fact, repeatedly said, we just gave what was our duty. Somebody gave us a request for recommendation, so we recommended. We didn't do anything more. We didn't put any pressure. We didn't hold a gun to the head of the minister, etc., etc. And the charge against the minister is that you passed some of those slips on, you passed on to the officer concerned. Now, my lords, assuming that that is correct.
Sir, there is one proposal. We will hear you on the 482, this court will hear your 482 application. But alternatively, very tentatively, if this is the observation that I make today, then I will fix the matter for hearing on the day in April which is suitable for you. That this matter is remanded to the learned judge to consider the question of discharge, whether the prosecution has any evidence against your client, to consider the question of discharge instead of relegating your client to a full-scale trial, if that can be done. That is the alternative.
Well, that's an alternative that is not entirely unattractive, if I may say so.
So we will consider both. I will consider both points on the day fixed for hearing. That is which April 7th.
I believe just showing to your lordships the order on charge in the context of the charge sheet would satisfy your lordships on both these paths, one or the other, depending on what your lordships believe is the better path to follow.
Yes.
We can do that, Lord. I'll be grateful. I'm grateful that your lordships have indicated at least the direction that we should try to urge.
Prima facie, it seems a little difficult to throw the proceedings, to nip it in the bud.
I appreciate that. I appreciate that.
But then, as far as your submissions are concerned, at the time when the question of discharge is considered by the trial court, it would be very, very relevant whether they have any evidence against your client to substantiate this.
Grateful, Mullahs. I understand that this is a prima facie suggestion, Mullahs, and I'm deeply grateful.
Prima facie.
I will try to build on it. I'll try to build on it and see if I can persuade your lordships.
Yes, yes.
Deeply grateful.
Yes.
Deeply grateful.
Yes, Mr. Salman Khurshid, learned senior advocate, appearing for the accused number 1, opens his arguments. In support of the proceedings under section 482 of the Criminal Procedure Code taken out by his client. Full stop. His arguments are not concluded. Considering the convenience of all learned counsel and the court, the convenience of the court and all learned counsel, further hearing of this matter is fixed on 10th April at the first sitting of the court. 10th April.
Please, my lord. Please.
Thank you. Thank you. It was a pleasure to hear
Deeply
you.
obliged, my lord. Deeply obliged.
Deeply.
Item number 1 and 2.
No, when we did to fix Salman Khurshid's matter? You said which one was the holiday? 7th. We fixed it on the 9th. 9th it is fixed.
My lord, item number 1 and 2, my lord, similar matters were listed yesterday, my lord. Losses issued notice. It's against the same common judgment passed by the 11th single judge, my lord. And those matters are fixed on 24th, my lord. Notices have been issued.
Is there any application for condonation of delay?
My lord, we have made an interim prayer in the writ petition itself, my lord. In the writ appeal. But there is a delay in filing the appeal, my lord.
Other matters delay has been condoned.
No, my lord, only notice was issued yesterday, my lord. The 2 matters,
So here also it has to be served.
my lord.
You have that order, yesterday's order. Make the same type of order.
My lord.
Returnable on the same date.
My lord. Deeply.
Item number 3.
State holiday on what state was?
Local for video.
Khasi festival.
May it please your lordship, in pursuance to your lordship's order dated 21/11/24, your lordship, we have filed an action taken report on the banning of the single-use plastic as well as waste management.
We need a more detailed report, detailed action, details of action taken.
Yes.
Your Lordship, here they have the different blocks in the East Car Sales District, Your Lordship.
Because
Inspection drives are being taken up, Your Lordship. Alternatives are also, we are promoting
awareness
alternatives.
program, all right.
Yes, Your Lordship.
Preventive measures,
Inspection drives have been taken up.
where?
Inspection drives in the different shopkeeper.
Give details, areas, places,
Okay.
what kind of inspection, how long the inspection lasted,
Here the, Your Lordship,
promotion of alternatives,
yeah, promotion of alternatives are also there, Your Lordship.
training sessions, where they were held, with whom.
With the stakeholders, Your Lordship. And actually, Your Lordship, here the report is in respect of the
Now-
different blocks.
Plastic collections drives were organized.
Yes.
In collaboration, the collected plastic waste was collected. Where they were organized, what weight or volume of
Plastics were collected.
waste, these details are required. We'll give you time, but
Okay, Your Lordship. But in this case, Your Lordship, community participation and continued,
the block
Effort is
development
required.
officer's office has successfully initiated steps to enforce the ban on plastic items below 120 microns. How? In what manner?
by
Some
holding
details are
awareness programs and by doing the inspection drives and all that, Your Lordship. Your Lordship, if Your Lordship may kindly see, these report includes reports from the different blocks in the East Car Sales, not only of one block, Your Lordship.
Because whatever may have been the order of the earlier bench,
Yes, Your Lordship.
it is not feasible or practical to entirely eliminate plastic,
That is true, Your Lordship.
because the environment may be protected to some extent, but the economy will be strangled.
Collapse.
Because, say for example, jute is many times more expensive than plastic. That is why jute has been replaced by plastic. You also consider that?
My lord, yes, my lord. And these reports, my lord, who have been just handed over just now to me also, my lord. I would like to go through also the
No,
reports.
no, you
my
go
lord.
through it. It is a general report. We are asking for a more
Detailed
detailed
report.
report, and we'll keep the matter after a couple of months.
My lord, my lord.
In this public interest litigation, the powers of the court were invoked by the writ petitioner asking for total ban of plastic in the state of Meghalaya. Paragraph. On 16th August 2024, this bench, then presided over by the then Chief Justice, made directions for total ban of plastic items in the state. Paragraph. On 21st November 2024, the matter came before us. Next, we, amongst other things, made the following observations. Stop. Next, the properties of plastic has made its use widespread. In storage of materials securely and durably. And used to make containers, bags, bottles, and other storage materials. Nevertheless, it has a very serious adverse impact on the ecosystem, environment, and health of people. Paragraph. By our order dated 21st November 2024, we inter alia directed the administration to ban the manufacture, marketing and use of plastic less than 120 microns and seize those materials wherever they were being used by making inspection of public places. We also directed the administration to take measures for proper management of plastic waste. Mrs. T. Yangi, learned Additional Advocate General, has placed before us a report of the Block Development Officer Mountaineeru CNRD Block dated 10 January 2024, showing the action taken by the government in furtherance to our earlier order. Next, it is a short report.
If I may, Your Lordship, interrupt. The block development officers of other blocks have also submitted their report, Your Lordship, and it is a part of the report, Your Lordship. Not only Maukenrow, Your Lordship, the other blocks are also there. It's
Similar.
more or less along the same lines, Your
All
Lordship.
right. Of block development officers of diverse administrative blocks. Don't give the date. The reports are short, containing broadly the action taken. We find that awareness camps have been held, meetings have taken place with stakeholders, the awareness was sought to be reached to students in schools, preventive measures like inspection drives, promotion of alternatives to plastic like cloth bags, jute bags, paper packaging. Was made. Plastic wastes were collected. And people persuaded to discard single-use plastic. The ban on plastic items below 120 microns was, quotation, successfully initiated, unquote, according to the block development officer, Maukenru CNRD block. More details about the action taken by the administration are required. when it is reporting conduct of awareness programs, the date, location, time, and the stakeholders involved in such awareness. The details of the awareness are necessary. With regard to preventive measures, where, when, and in what manner inspection was carried out, what was the result of such inspection, are needed. The details of the quotation plastic collection drives, like the weight or number of plastic items seized or plastic waste collected, weight, and the place from which they were collected, and when should form part of the report. The action taken against users of items below 120 microns is also necessary, together with an elaboration of the elimination together with an account of now please read out the sentence. Together with detailed information about elimination of single-use plastic. Paragraph. We are satisfied with the action taken so far by the government, but we do treat this as only a beginning of the journey. Paragraph list this public interest litigation once again on 14th May. The respondents will file another report in this court by 12th May, circulating copies of the report to be filed and the report filed today in court. The report considered today in court to advocate to the petitioner.
The petition, my lord.
Item number 4.
Obliged.
Oblige, your lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I'm praying for adjournment, Your Lordship, today. Let it come after 2 weeks, Your Lordship.
Yes.
Your Lordship, I have no objections.
Same order as 25-2. Adjourn till 26th March.
Obliged.
Obliged, Your Lordship.
Item number 5.
It's a hearing matter, my lord.
Ready for hearing?
I'm ready, my lord, subject to convenience of your lordships because due to paucity of time.
What is this matter about?
My lord, we are challenging a certain amendment to the service rules, my lord, where, my lord, the chances of promotion has been reduced from by a percentage, my lord.
During service,
Yes, my lord.
there was some selection or recruitment in
No, my lord, no.
Then?
We are in service, my lord. There were a particular set of rules of subordinate service in the fishery department of 2008, which was in operation. Then subsequently in 2017, they come up with another set of rules for the higher post. And this particular post was carried over from the low subordinate service to the higher service, my lord. Now there also there was some ambiguity. So we've been making representations to cure the ambiguity, my lord. Subsequently, they've come up with an amendment which is under challenge before your lordships.
how many matters are there tomorrow?
This is this. 8 matters. This is purpose. I tell you also.
Let it retain its position in the list.
My lord.
As and when time permits, we will take it up.
My lord.
You're for the appellant.
Appellant, a writ petitioner, my lord. It's before the division bench because we are challenging the rules.
Learned counsel for the writ petitioner commences his argument, but does not conclude the same. Let this writ retain its position in the list.